1993, British reinsurer companies tried to coerce American reinsurer companies, collectively via Lloyd's of London, to abandon policy practices that were beneficial to consumers but costly to the reinsurer companies. The state of California filed a lawsuit against the reinsurer companies, stating that this was violating American antitrust laws, specifically the Sherman Act. The Sherman Act does not prevent a company from gaining a monopoly through being better than its competition, but rather prevents a company from getting a monopoly due to an unfair advantage. The Sherman Antitrust Act is an American antitrust law passed by Congress in 1890, meant to protect the competition of businesses by preventing unfair monopolies and cartels. The plaintiff, California, claimed that the changing of these policies by British companies, which was illegal in the US but legal in the UK, gave the British-based companies an unfair advantage over the American ones who could not implement these policies. The defense, Hartford Fire Insurance Co., argued that they were allowed to implement these principles because they were legal in the United Kingdom from which they were based, and brought forth a principle known as comity. Comity is a principle of legal reciprocity, in which one jurisdiction will extend certain courtesies to the laws of other nations. So because these principles are legal in the United Kingdom, America should value their legality. Initially, the U.S. District Court dismissed the case and agreed with the defendant on the principles of comity. However, the Court of Appeals reversed the District Court's dismissal and brought the case in front of the Supreme Court. The Supreme Court had to decide whether or not the Sherman Act had jurisdiction over companies that were foreign-based and whose actions were legal in the countries to which they came from. The defense argued that the Sherman Act had no jurisdiction over their actions. They brought up the Foreign Trade Antitrust Improvement Act of 1982, stating that the Sherman Act does not apply to foreign conduct unless the conduct or commerce has direct or foreseeable effect. The court disagreed with this and found that the conduct at hand clearly had direct effect. Both the plaintiff and the defendant agreed that these practices were legal in the United Kingdom, but the court ruled that the fact that the conduct is lawful in the state in which it took place will not of itself exempt them from application of U.S. antitrust laws, even if that foreign state has a strong policy to commit that conduct. The Supreme Court stated that it is well established by now that the Sherman Act applies to foreign conduct that was meant to produce and did in fact produce substantial effect in the United States. The ruling is significant because it means that the Sherman Act can be used to restrict what foreign-based companies can do in America if it affects the American market and the competition of the American market, even if these acts are legal in the country from which they are based.